Good afternoon and welcome to the constitutional question, the right to save the environment. My name is Chandler Randall and I'm the manager of educational programs here at the Environmental Law Institute, and I am so delighted to welcome everyone to today's program. ELI is proud to offer programming on cutting edge issues in environmental law and policy, and it is such an honor to have you join us today for this special program. Throughout the program, we will be taking your questions, so please submit your questions through GoTo's question box, and please do not wait until the end. Send in your questions as soon as you think of them. I would like to thank our outstanding panelists for joining us today to lend their expertise to this webinar, and while they will be introduced briefly, the full speaker bios are posted on our website, eli.org, and I really encourage you to check out their expertise in more detail there. As we begin, I would like to briefly introduce today's panelists in their speaking order. Up first, we have Senator Franklin Curry. Franklin Curry served in the Pennsylvania House of Representatives from 1966 to 1972 and the Pennsylvania Senate from 1972 to 1980. As a state representative, Curry was the author and lead advocate of the legislative proposal that became the Environmental Rights Amendment to the Pennsylvania Constitution. He is also the author of The Constitutional Right to Save the Planet, published in April of this year. John Dernbach is professor of environmental law at Widener University Commonwealth Law School. He is a nationally and internationally recognized authority on sustainable development, climate change, and environmental law. He is the director of the Environmental Law and Sustainability Center and brings his expertise into the classroom in courses on property, environmental law, international law, and sustainability. Julia Olson serves as executive director and chief legal counsel for Our Children's Trust. Julia founded Our Children's Trust in 2010 to lead the strategic legal campaign on behalf of the world's youth against governments everywhere. Julia leads Juliana versus United States, the constitutional climate change case brought by 21 youth against the US government for violating the Fifth Amendment rights to life, liberty, property, and public trust resources. And finally, our last speaker will be Barry Hill. Barry Hill is a visiting scholar at the Environmental Law Institute and adjunct faculty at Vermont Law School. Mr. Hill has experience in government, where he served as senior counsel for environmental governments of the Office of International and Tribal Affairs, as well as the director of the Office of Environmental Justice, both at EPA, as well as in private practice. He is also the author of Environmental Justice, Legal Theory and Practice. While much more could be said about each of these speakers, I want to keep it brief, and I really do encourage you to read more about them on our website. Thank you all so much, and with that, I will turn things over to our first speaker, Franklin Curry. Thank you all so much.
Chan, thank you. What I'd like to do is start by describing the book and how it came to be and what I think it does for the future. The idea of the book came to me about 3 years ago because the 50th anniversary of Article 1, Section 27 of the Pennsylvania Constitution was observed on May 18th of this year. So that was the idea. And let me go back to how this whole thing began. The whole thing began in 1966 when I ran for the State House of Representatives. I ran on a clean streams issue. The incumbent representative, who was the senior Republican in the state legislature, chairman of the Appropriations Committee, voted against bringing coal companies under the Clean Streams Law. And I made that issue and I won. Well, what was significant was that this was such an upset that my picture was carried in the Philadelphia and Pittsburgh papers, etc., as the beginning of the movement of environmental law, environmental issues as a political issue. So I had no idea about writing constitutional amendments. I just got to the House because I won on that issue. But 2 years later, so many more legislators like I was got elected, and we ran the House Conservation Committee, where I was one of the top leaders because of what I had done. The chairman was John Laudadio. But anyhow, we passed about 12 different environmental bills in 3 or 4 years. We passed more environmental bills than the entire history of the state before or after. But at that point, while I was serving on that committee and all the bills came through, I didn't write most of the bills. I only wrote 1 or 2, but all of them came through the committee I served on. And it occurred to me, we've got to find a way to preserve what these bills are doing. These bills can be repealed as fast as we're passing them, or they can be amended to weaken them. So we need something permanent. That's when I thought of the idea of an environmental amendment to the Constitution came to me. We needed something in there that would establish broad principles instead of policy for the state for the future generations. So I came up with three basic ideas. One is the public has a right to a decent environment, clean air, pure water, etc. I'm abbreviating. I just what the language is. Second provision was the public natural resources of Pennsylvania belong to all the people. And the third principle is the government must serve as trustee of these resources for future generations. So those are the three principles I put in. The bill, with this, my original language amended several times, but on Earth Day 1970, with Gaylord Nelson on the podium for the first Earth Day in Pennsylvania, we approved the Senate amendments to my bill and got it ready to go to the public the following year. The following year, the bill was reintroduced, and then it went before the public, and on May 18th, 1971, the people of Pennsylvania approved this amendment by a vote of 4-1, over 1,000,000 to 250,000. There were 4 other amendments on the ballot that day. 2 of them were defeated. Women's rights passed, but it only passed 2-1. And my wife and I kid each other about that. I'm not downplaying that, but it's interesting. Environmental rights, or the environmental thing, passed 4-1. So anyhow, it passed. And then it went on the books. And I thought something would begin to happen, but it didn't. And I'm sure John Dernbuck will go into this in greater detail. But the courts of Pennsylvania soon anesthetized the amendment. They adopted a test called Payne versus Kasab, which really was a cost-benefit analysis. And it was the law it was the main test for interpreting Article 1, Section 27 for about 40 years. Nobody succeeded in stopping any invasion in the environment, and until 2013, when Justice Castile came up with the opinion, which he wrote in Robinson Township, and this is all in the book, that in Robinson Township, he declared that you have to use the plain English language in reading the Constitution, a provision on the environment. And he really said that the Payne versus Kasab test belonged in the judicial wastebasket. Well, anyhow, the amendment got new life. Succeeding cases, the PEDF cases brought by John Child and the Pennsylvania Environmental Defense Fund, reinforced what Castile had done. And now that Article 1, Section 27 is alive and well and full of vigor. So I think that's great. But I also thought that it's not enough to celebrate this, because something has now overwhelmed us that was not present when we wrote Article 1, Section 27, and that's climate change. At that time, in the late 60s and early 70s, nobody heard of climate change. Or if they did, they didn't talk about it. Nobody talked about natural gas or Marcellus Shale, things like that. But the big thing is they didn't think about climate change, and of course, now it is an overriding issue. As Gail Collins said in the New York Times a few weeks ago, apocalypse is here now in the environment. So we've really got to do something to do it. So I therefore put most of the second half of the book on how this amendment can be used in other states at the federal level. That's why the title of the book was changed. It's not a Happy Birthday, Pennsylvania. It is, as you'll see in the title, it's the constitutional question to save the planet. Because the 3 basic principles in the book, in the amendment, which I expanded on in the book, can be used, and they should be used to stop climate change. So the rest of the second half of the book reviews the history of other states in the union, talks about copper in Montana and how that relates to Pennsylvania, and it shows that most states don't have constitutional amendments on the environment. Matter of fact, one of the best things of the book is the appendix. If you look at the appendix 4, it shows all of the states of the union, all 50, and how they compare to Pennsylvania. And the crazy thing is how few of these states have any constitutional provision whatsoever. Well, the question then is, will we make this a federal amendment? Will we make the Article 1, Section 27 principles part of our U.S. Constitution? And the last third of the book is dedicated to advocating that we need this. We want to make, I think, explicit what Julia is going to argue is implicit in the Fifth Amendment. And I think she's right, but she hasn't won, and I hope she will. But you know, it's tough sledding, but this would make it explicit. It might make it easier. So that's what I'm advocating in the book. And it also describes that the leadership of the United States is definitely on the line here. If we're going to be serious about leading other countries, we've got to start at home. And the best way to start at home is to show a commitment through a constitutional amendment. So that is the argument there. Now, the Biden administration, I point a special afterward, I put in the book, after the election. Biden's environmental plans are great, and I hope they succeed. But as Ann Carlson pointed out to me when I interviewed her at UCLA, the problem with legislation or programs is they can be repealed or amended. You look at Trump repealed or brought back 65 environmental provisions that Obama had proposed. He pulled out of the Paris Peace Treaty or the Paris Climate Treaty. So this is what is an undulating effect, depending on the elections. One of the reasons we want to get the amendment in my opinion, is so you don't have this undulation. You got to make this a basic policy of the U.S. government that its job is to protect and save the environment as well as anything else. Now, let me just close by saying what this book advocates really is revolutionary. Because what it would do is take, right now, environmental issues are something that Congress occasionally accommodates through a statute. But this would really revolutionize that and say, look, you got to make this a fundamental responsibility of government, just like the responsibility to protect the United States from foreign and domestic enemies. And I can't think of any more appropriate enemy to be fighting than climate change. So sure, it's revolutionary. It would make every elected official in the federal government would have to swear to uphold this. It has to be a guiding principle. Now, this is revolutionary, but I say, so what? Our country was born in a revolution. And at that time they did it, they didn't talk about the Constitution that provided it, did not provide to deal with blacks or slaves. They did not deal with women's rights, and they did not protect the environment. Now we have the 13th, 14th, and 15th Amendments dealing with the blacks and slaves. That's long overdue, and that's there. We have the 19th Amendment on women's political rights, and now it's long overdue to put environmental protection on the same level as these other provisions here. So that's what the book calls for, and I'll be glad to get your reactions to that at the appropriate time. So that's enough for me. Thank you.
Thank you so much, Franklin. I will now hand things over to John Dernbach.
Well, thank you, Chandler, and thank you, Franklin. It's a privilege to be on this program, and I'm going to try to advance the slides. And I'm not succeeding.
If you click the PowerPoint again, you should be able to take control, and if not, I'm happy to control the slides for you.
I'm clicking on the PowerPoint, and it's not moving. Why don't you run the slides? Okay, so there we go. The story I'm going to tell is a little more detailed story about what has happened with Article 1, Section 27 in the courts over the last 50 years. And as you can see from the title here, it's a story about abandonment and then restoration. Next slide. So before we get started, it's useful to take a look at the text of Article 1, Section 27. What I want to draw your attention to in these 3 sentences is there are really 2 things going on. In the first sentence, the public has a right to clean air, pure water, and the preservation of 4 named values in the environment: natural, scenic, historic, and aesthetic. That's the first part of the amendment. The second and third sentences go together, and taken together, they create a public trust in a category of resources called public natural resources. And the Commonwealth's job is to conserve and maintain them for the benefit of everyone, including future generations. And so as I go through the slides, I'll sometimes refer to the first part of the amendment or the public trust part of the amendment, and that's what I'll be doing. And that's what I'll be referring back to. Next slide, please. Just an homage to Franklin Curry, but for him, we wouldn't be here. And this is his famous campaign picture that got him elected to the state legislature.
John, I have to interrupt you for a minute. That picture was my wife's idea, and she took the picture. Give credit to Elizabeth Curry for the photo.
There we go. Okay, so you heard it here first. Next slide, please. So the problem that you have from the standpoint of the courts is there's no federal analog. So you don't have hundreds of years of experience thinking about what environmental rights means. There really wasn't much environmental law when this amendment was passed in 1971. And courts have had, and commentators have pointed this out, a lot of difficulty thinking about, well, how do you make environmental rights work? And particularly, how do you reconcile them with economic development? And that, I think, helped explain the long path here to judicial recognition. Next slide. So we got off to a bad start in Pennsylvania. The Attorney General, environmental rights are mostly rights that we have, and every other rights in Article 1 of the Pennsylvania Declaration of Rights, which is Pennsylvania's analog to the Bill of Rights, and the federal rights as well, are by and large rights that we have as against the government. And what happened here is the Attorney General treated the first sentence of the amendment as a cause of action against a private developer operating on private property to build an observation tower right outside of Gettysburg Battlefield National Park. And although the Gettysburg decision was on some level a win for the Environmental Rights Amendment, it frightened a lot of people into thinking that if this were really a grant of power, maybe the legislature ought to be asked to authorize the particular things that occur under that. And so it created a constant, recurring, never-ending question about whether the Environmental Rights Amendment was actually self-executing. Next slide, please. And then things got worse. Some citizens challenged a street widening project in Wilkes-Barre, Pennsylvania, involving a half an acre of a public park. And they said, look, this violates the public trust. And the Commonwealth Court looked at this, and then it looked at the Gettysburg Tower case, and it said, you know, we're seeing the Environmental Rights Amendment being used for really pretty small stuff in terms of environmental impact. And we're thinking that the text of the Environmental Rights Amendment really isn't suitable for all of this. And so because judicial review needs to be realistic and not legalistic, here signaling that the court was going to invent its own test, the court actually did invent its own test. Next slide. This is the Payne versus Kassab test that Franklin talked about. It's a balancing test. It's kind of a cost-benefit test. I'm not going to go through the particulars of it, but one thing that it's really important about this test is it has virtually nothing to do with the text of the Environmental Rights Amendment. It was a remarkable act of judicial activism, and it had a profound effect in making the Environmental Rights Amendment go dormant, as Franklin pointed out, for more than 40 years. Next slide. A student and I, mostly the student, did a study of how the Payne versus Kassab test worked. And basically, the way it worked is the people that were using the amendment to challenge something that the government did hardly ever won under this test. Um, but when I started out as a young lawyer in the early 1980s at the Department of Environmental Resources in Pennsylvania, Payne versus Kassab was what the Environmental Rights Amendment actually meant. And I remember looking at the text of Section 27 at the time and thinking, gosh, you know, wouldn't it be nice? These are really wonderful words. Wouldn't it be interesting if the courts treated these words like law? Next slide, please. So actually, that began to happen in Robinson Township, a Commonwealth, or excuse me, Pennsylvania Supreme Court opinion in 2013, holding unconstitutional several parts of the Marcellus Shale regulatory statute called Act 13. 3 justices based their opinion on Article 1, Section 27. This had never happened before. Section 27 had never, ever been used to hold a statute unconstitutional. And although it was only a plurality opinion, the plurality opinion, the typed manuscript version of the plurality opinion that was originally published was something like 160 pages long, and it's a remarkable exposition of what Section 27 could mean. Next slide, please. That opinion created a roadmap that subsequent decisions have followed, even though it was only a plurality opinion. Several features of this opinion are worth pointing out. One is that then Chief Justice Castile strongly believed in following the text of the Constitution, and he's actually spoken at Federalist Society meetings about the same issue. And that, I think, helped the cause here. He also is pretty sensitive to, and we've heard, Franklin and I have heard him speak publicly on this, about environmental impacts that have occurred to Pennsylvania's natural resources over the years. And a third thing that I wanted to flag in this slide is that when he was at a dedication of what amounts to a sort of a small monument to Franklin Curry, earlier this year, he gave a short speech in which he quoted 2 passages from the Environmental Rights Amendment, and he says, and both of them contain the term sustainable development. He used that term several times. And what to me that meant was that he saw that there was a way to interpret Article 1, Section 27, the Environmental Rights Amendment, in a way that was consistent with economic development. And I think that helped thread the needle here in terms of the aversion that the Pennsylvania courts had traditionally had to recognizing environmental rights. Next slide. So the next big decision, this is the case that turned a plurality opinion into a majority opinion, is Pennsylvania Environmental Defense Foundation versus the Commonwealth. And basically what happens here is you've got oil and gas drilling on state lands, you've got royalties that are received. Typically over the years, that's been kind of a mom and pop operation, a couple $1 million a year, no big deal, impacts aren't that large. But with shale gas and the economic meltdown that occurred in 2008, the state saw an opportunity to make hundreds of millions of dollars from drilling on public lands and to use that money to balance the budget. And the court said, you can't do that. You can't do that. And I want to walk you through a little bit of the court's reasoning on that. Next slide, please. This is a summary of oil and gas leasing on state lands, and I've already teed up the key messages from that slide. So next slide, please. So as a starting point, the PEDF court said that the Payne versus Kassab test is no more. That was a really big deal, and it basically changed the landscape. Between this and the Robinson Township case, the remarkable legal kind of almost cognitive change that occurred for Pennsylvania lawyers, policymakers, and judges is to actually look at the words of Section 27 for the first time and take them seriously. Before that, as I've said, what you would do when you were writing a brief is you would quote Article 1, Section 27 because you had to, and then you'd get to the Payne versus Kassab test, which was the real law. Now, people are all looking at Section 27 in the text of it. Next slide, please. So, and this is really where the court focused on. They said, look, the proper standard of review is the text. And then it added principles of trust law in effect at the time of its enactment. And I think the existence of trust law and the use of trust law is something that's been important to Pennsylvania, particularly in the public trust part of the amendment. The other, it identified two sets of rights to the people. I mentioned those earlier, I'll come back to that in a second. And then settled once and for all, I hope, the issue of whether the amendment is self-executing and said, well, look, at least against the government, you don't need legislation to carry out Section 27. Next slide, please. So I've told you what the first sentence is. The court says, and this is part of the exposition, if you will, of Section 27 that you got in both, first in the Robinson Township case, and then it happened again in PEDF, where the court referred back to Robinson Township, essentially providing kind of a roadmap of its thinking about how to interpret this. And the key thing here is that this clause limits the state's power to act contrary to these rights. So it's a limit on government authority. Next slide, please. The public trust language, the court says, includes state parks and forests as well as the oil and gas they contain. And so, of course, that brings the oil and gas leasing program under the public trust. It identifies present and future generations as the named beneficiaries. And then it says, and this is important, an important point that a lot of local governments and even some state agencies haven't fully thought through, is that there are a lot of trustees out there. Agencies and entities of the Commonwealth government, all of them at the state or local level, have trust responsibilities. Next slide, please. So what are the duties of the trustees? Well, the duties of the trustees are to prohibit the degradation, diminution, or depletion of these resources. And the additional point, as you can see here, is, well, if the harms might result from direct state action, that certainly counts. But the state also has a duty to prohibit private parties from degrading public natural resources. And then it goes on to make a provocative point that the Commonwealth has to act affirmatively via legislative action to protect the environment. Next slide. It said, as I indicated before, that traditional trust law is to be used to determine the meaning of a public trust. So principles like loyalty, impartiality, and prudence that you see in traditional trust law are principles that the Pennsylvania court, the Supreme Court, is willing to use to apply to help put meaning, additional meaning, or fill out the meaning of Section 27. Next slide, please. So after saying all those things, the court said, well, okay, what that means is that if you sell oil and gas that is part of the public natural resources, the money that comes from the sale of those resources is also subject to the public trust, the obligation to conserve and maintain. That money cannot be used to help balance the budget. Next slide, please. Then, in a subsequent case, just decided this past summer, the court says, well, what we said earlier about royalty money being subject to the conserve and maintain obligation also applies to bonus money and rental money and penalty payments from oil and gas leasing. Once again, this is a majority opinion. And what's really interesting, I think, about this opinion is the strength of the language that it uses when it talks about the intergenerational or cross-generational aspect of Section 27. And this sentence is, I don't like to read from PowerPoints, but this sentence is actually worth reading. The language of Section 27 unmistakably conveys to the Commonwealth that when it acts as a trustee, it must consider an incredibly long timeline and cannot prioritize rather the needs of the living over those yet to be born. It's the strongest statement on intergenerational equity that the court has used yet. Next slide, please. So what else is going on? Well, there's a whole lot of other cases. There's a whole lot of other cases. There's cases in Commonwealth and the Supreme Court. There's cases in Common Pleas Court. There's cases before the Environmental Hearing Board. And I want to just give you a little bit of a sense of some of the issues that have yet to be that are being teed up or have yet to be decided. Next slide. So one issue that the Supreme Court is going to be hearing, this is still another appeal by the Pennsylvania Environmental Defense Foundation and John Child, is, well, how can the royalty money and this other money be spent? What does it mean to spend money to conserve and maintain public natural resources? And the state basically is saying, well, look, what we'd like to do is use a lot of this money to pay operating expenses for our environmental agencies. DCNR, in particular, Department of Conservation and Natural Resources, has been making that argument, and a lot of them, and it's quite a lot of money. And maybe we'd like to restore state park forests and parks with that money. The PEDF says, well, but that money used to be, your budget used to be based on the general fund. And simply spending money on salaries and expenses doesn't really do anything to protect, doesn't necessarily do anything to protect the corpus of the trust, which is physical natural resources. As you can see here, there's a lot of money at stake, and it'll be interesting to see what the Pennsylvania Supreme Court does with that. Next slide, please. So another question is, well, what role does the first clause, the Gettysburg Tower Clause, have now? The court has pretty firmly moved in the direction, the Supreme Court has pretty firmly moved in the direction of understanding environmental rights as against the government. But you still got a live decision out there that still has some precedential value, presumably, that says you can, that the state, at least the state, can use the first sentence of the amendment as a cause of action. And of course, that makes a lot of private landowners and certainly lawyers for private landowners nervous about where that might all go. Next slide, please. So still a third question is, well, what's the best way to implement the Environmental Rights Amendment? Is it best implemented through litigation? Well, certainly that's the way it's worked so far. But there's certainly other possibilities out there. Guidance to state agencies, regulations, perhaps legislation that would help implement parts of this. And I'm not arguing for any of that, but that issue is certainly up in the air. And I'll give you a quick example of this. If the state has an obligation to conserve and maintain public natural resources, wouldn't it be a good thing maybe to have an inventory of all of those natural resources and for the state to be reporting periodically to the public about how those resources are doing? That's something that an ordinary trustee is obliged to do, and that's something that perhaps the Commonwealth should also be doing. Next slide, please. There's a boatload of additional questions that I could raise here, but obviously one of them is, what about climate change? I think it almost certainly applies to human-induced climate change. Bobby McKinstry and I have written a long article about this, and the state is beginning to move in the direction of regulating greenhouse gas emissions by joining the RGGI program. And I expect that in the litigation that follows on that, Section 27 is going to play some role. Next slide, please. We have a boatload of resources on a Widener website about Section 27 if you want to learn more. One last thing I would say about Section 27 is there was a prediction when the PEDF and Robinson Township cases were decided that this was all going to lead to apocalypse for the private sector and development projects were going to be stopped. The practical impact is really quite different. What a lot of lawyers are seeing is that if there's a particular problem that a project doesn't address, the lawyers are giving the project developers advice to fix that to avoid Section 27 litigation. And so in sort of on an ordinary day-to-day basis, there's been a certain amount of that as well. That's all I have to say for now. And again, it's a privilege to be part of this program.
Thank you so much, John. I really appreciate your remarks. I will now hand things over to Julia Olson. Thank you so much, and over to you, Julia.
All right, thank you. Let me make sure I can work this PowerPoint. I don't think it's working, Chandler.
All right, well then I will go ahead and control them for you.
Don't know why it worked when we practiced. All right, hi everybody, I'm Julia. It's a pleasure to be here. Thank you, Chandler and ELI, for hosting us. And you know, I just want to acknowledge that Franklin Curry was really a visionary in the 1970s and has helped us get to where we are today. And it's not far enough, but really laid some vital groundwork. And it's an honor to be here with the three of you to talk about this. So I'm going to start with just a brief summary of the Juliana versus United States case and where we're at for those who are not familiar with it or don't know the latest update. So what we are trying to do is fill the void of where we don't have an environmental rights amendment in the US Constitution and in other constitutions around the country and the world to really have courts acknowledge the implied right that is part of our basic rights to life, liberty, and our federal public trust doctrine in the case of Juliana. And so this case was brought by 21 young people. It's brought under the Fifth Amendment, under the Substantive Due Process Clause, and then also the Equal Protection Clause. And the core challenge of the case is that we're suing over the United States fossil fuel energy system and the policies and practices that continue to promote the US fossil fuel energy system. And you know, at its core, this case is about seeking a stable climate system, about addressing the climate crisis and the US government's dominant role globally in perpetuating that crisis and really causing it. It's also a case about intergenerational rights, protecting children and future generations to the vital natural systems they need for survival. It's also a case that's really about, oh, and I'm forgetting the slide. Sorry, Chandler. Do you mind moving it forward, please? Those are the clients. They are an awesome group of young people. And if you can move it forward again, please. All right. And so I wanted to just mention this when we're talking about whether the right is implied or not. This is James Madison, of course, who drafted the Fifth Amendment. And back in 1818, he was speaking to a group of farmers and said that basically the atmosphere is the breath of life. Without, deprived of it, we all equally perish. And he was referring to humans and animals and plants. So going back to like even the early days of our nation, there was very much an understanding that the atmosphere and air and water were vital to life. Next slide, please. So these are two of my clients, Aji and Tia, and this is what life out west is starting to look like in the summers. And so part of the Juliana case is really about impacts to the health of young people. And, you know, children, it's a children's rights case because not only are young people exposed to the same types of air pollution that adults can be exposed to, but because their bodies are still growing and developing, they're actually affected very differently than adults are. Their respiration rates are faster, and they're outside more, and their physical and mental health impacts are very significant, and in some instances really dangerous. So part of the Juliana case is also about these young people not just being little adults or smaller individuals, but really being distinct. They can't vote, they don't have political power, they don't have lobbyists, and they're very different physiologically from adults. So all of that is a really important part of the case. And so this case was filed in 2015. It's been on a roller coaster of procedural hurdles. We've been up to the Ninth Circuit 4 different times. We've been up to the US Supreme Court twice. We are now back down in the district court here in the District of Oregon in Eugene in front of Judge Ann Aiken. And we have sought to amend our complaint. So we've sort of addressed some of the issues that the Ninth Circuit Court of Appeals identified related to standing and redressability. And so we have a new complaint that's slightly altered, same basic claims, moving forward to a decision on that motion to amend, which we're hoping will come any day now, but there's no set timeline. If Judge Aiken grants that motion to amend, then the Juliana case is back headed to trial if the Department of Justice does not seek extraordinary measures to try to stop it. And so if we could go to the next slide, I'll talk a little bit about what that could look like. So this is just sort of an image that represents what's sort of at stake at this moment. If we're allowed to go to trial, according to the district court, the only final hurdle that could prevent this trial would be another petition for a writ of mandamus. And that decision is made by the Solicitor General or the Attorney General of the United States. And really, that would be the only wall or the dam stopping these young people from getting into court and really putting forward their evidence at trial. So we're hoping that won't happen. We're hoping the Biden administration will follow ordinary trial litigation practices and come to court and defend the case if they choose to do that. And next slide, please. So I'm happy to answer more questions about Juliana, but while it's sort of our flagship case, we also have other cases. And at the same time that Franklin was doing his work in Pennsylvania on the constitutional amendment, Montana was also doing work. And so in the early 1970s, Montana amended its constitution to include Article 9, Section 1. And that article says, the state and each person shall maintain and improve a clean and healthful environment in Montana for present and future generations. And it has other provisions too that require the prevention of degradation and the protection of environmental life support systems. So we filed suit in Montana against the state on behalf of 16 young people. And this case also challenges the fossil fuel energy policies and practices of the state of Montana as violating this constitutional provision and harming the youth of their state. And we beat the motion to dismiss. So we are now headed to trial in Montana State Court and are preparing for that case, which is really exciting. You may know that Montana is one of the biggest fossil fuel producers in the nation and play a really important role in fossil fuel production. So we're putting that on trial. And next slide, please. We have cases in multiple states, some of which have these explicit environmental rights provisions and others that don't. We're also using public trust doctrine laws to bring these cases on behalf of youth. We have new cases in development in Utah, Virginia, and Hawaii right now, along with the others that you see listed in this slide. And next slide. In addition to the state work that we do here in the US and our federal work, we're working globally. there are environmental rights provisions in probably most constitutions now around the world, either public trust provisions, environmental rights provisions. And so there are youth just rising up everywhere to bring these claims to protect their right to a climate system that sustains life. Next slide, please. And this slide shows just sort of the expansion of these types of cases that are happening all over the world. Next slide. All right, so I just wanted to bring another issue in really quickly, and then I'll wrap up. And that's, there's another ERA that we're all familiar with, and it's the Equal Rights Amendment, which finally had enough states vote to ratify in 2020, with Virginia being the 38th state. But unfortunately, other states had sort of repealed their ratification, and the deadline for ratification passed 4 decades ago. And so it's just an example of how these constitutional rights amendments can be very challenging and take a lot of time. And so I think it's important to have both a short-term effort and a long-term effort when we're looking at how do we really make permanent and codify constitutional rights with respect to environmental protection. And Chandler, if you could just skip to skip ahead 2 more. 1 more. Thank you. So for those who don't know, on Friday, this last Friday, the Human Rights Council of the United Nations actually voted to declare by resolution that a healthy environment is a human right. And so this was really a momentous occasion on the international scale to have that body, which was made up of, I think, about 45 countries approximately, really acknowledge this for the first time on that international level. And so I just wanted to flag that as we head into a discussion. And thank you so much.
Thank you so much, Julia. And with that, I will hand things over to our last speaker, Barry Hill. Just a quick note, I see that we have quite a few questions. Please do feel free to continue sending those in, and we will answer all questions at the very end. Thank you all.
Good afternoon, everyone. I'm honored to be part of this distinguished panel, and I want to thank ELI for having this panel discussion and inviting me to be part of the dialogue. The other day, McCarter Research Institute on Global Comments and Climate Change issued a study, and it said that at least 85% of the world's population has been affected by human-induced climate change. At least 85% of almost 8 billion people on the face of this earth have been affected by human-induced climate change. In 2021 alone, the study says that there have been 388 deaths in the United States and $100 billion in damages. Instead of talking about the constitutional right to save the planet, I'm going to talk about the constitutional right to address climate change and its adverse impact on human health. My message today is that climate change is a public health issue, and a human rights-based approach is required to protect the air we breathe, the water we drink, and the food that we eat. That's the goal of environmental justice for all. John and Franklin talked about the first principle, that the broad language of an environmental rights amendment, an ERA, can be used to address climate change because the essential principle of an ERA is that all people have a right to a healthy environment. Second principle is that the broad language of an ERA can be used to address climate justice for all. And finally, The third principle, broad language of an ERA, can be used to address environmental justice for all, which is obviously my passion. I'm going to focus my comments on a recently issued study by EPA and its climate change and social vulnerability in the US, a focus on 6 impact sectors. But before I talk about EPA's study, I want to talk about a UN Human Rights Council study entitled Environmental Justice, the Climate Crisis, and People of African Descent. That was issued October 5th of 2021. The study by UN experts concluded that in paragraph 63, the world is currently facing a climate crisis, environmental racism, pervasive toxic pollution, dramatic loss of biodiversity, and a surge in emerging infectious diseases of zoonotic origin, such as COVID-19. These interlocking environmental crises have a negative impact on a wide range of human rights, including the rights to life, health, water, sanitation, food, decent work, development, education, peaceful assembly, and cultural rights, as well as the right to live in a healthy environment. As Julia said, on October 8th, 2021, the Human Rights Council voted with 43 countries in favor of this human right to a clean, healthy, and sustainable sustainable environment. There were no countries against and 4 abstentions: China, India, Japan, and Russia. Basically, the UN was saying that environmental degradation and climate change are interconnected human rights crises, and that the most vulnerable segments of the population are more acutely impacted. Over the next couple of minutes, I'm going to show you how the Human Rights Council and EPA are united. The EPA study. This was a significant study, and it represented an important milestone in understanding the future impacts of climate change on different American populations, especially under-resourced communities in this country. Minorities and poor Americans most likely to suffer and to die from the worst impacts of global warming. EPA's report shows the degree to which 4 socially vulnerable populations. They are defined as income, educational attainment, race and ethnicity, and finally, age. These may be used to show that they may be more exposed to the highest impacts of climate change. The report quantifies 6 types of impacts, including those to health, from changes in air quality and extreme temperature, disruptions to weather-exposed workers, and flood threats to poverty. The one thing that is clear is that race and ethnicity are far and away the strongest indicators for heightened climate risk. And this is based on EPA's analysis of 49 US cities. Let me share with you some of the key findings of the study. And the study was started during the Trump administration and completed in September. Let me give you some statistics. It says that African Americans are projected to face high impacts of climate change for all 6 impacts analyzed in the report, compared to all other demographic groups. For example, with 2 degrees Celsius, African Americans are 34% more likely to currently live in areas with the highest projected increases in childhood asthma diagnoses. Black children are 34% more likely to experience asthma exacerbated by climate change. This rises to 41% under 4 degrees Celsius of global warming. It is a public health issue, according to EPA. To go on, 40% more likely to currently live in areas with the highest projected increases in extreme temperature-related deaths. This rises to 59% under 4 degrees Celsius of global warming. The report finds that African Americans are 40% more likely to die from higher temperatures than the general populations if global warming is kept to 2 degrees Celsius. If the world is allowed to warm to 4 degrees Celsius, on average compared with pre-industrial levels, Black Americans would be 59% more likely to die than the general population of the continental United States. Minority communities are also in line for more disruptions as sea level rise endangers coastal roads and other infrastructure. White people own a disproportionate share of the property that would be inundated in high warming scenarios, according to the study. Those are startling statistics. It was a comprehensive study, and it looked at, as I said, all issues, all areas in the United States, and it's rather chilling. Under-resourced communities are going to suffer, without a doubt. EPA's report supports the Biden administration's focus on environmental justice and climate justice. Upon its release, EPA Administrator Michael Regan said in a statement that it punctuates the urgency of equitable action on climate change. With this level of science and data, we can more effectively center EPA's mission on achieving environmental justice for all. But EPA does not have an environmental rights amendment in the U.S. Constitution. As Franklin pointed out, they don't have a federal ERA to work with. EPA does not have climate change legislation to work with at this particular point. Finally, EPA does not have environmental justice legislation to work with. So how is this going to be done on a national level as a practical matter if the agency does not have the tools? The UN report, let me go back to that, stated in paragraph 61 that addressing the climate crisis requires a human rights-based approach. That is why the experts recommended in paragraph 74C that countries like the US need to take urgent action to mitigate the climate crisis and address environmental degradation and environmental racism, applying a human rights-based approach, emphasize prevention and participation, focus on the needs of those most affected, and increase accountability. Address the root causes of systemic racism and interrelated environmental disasters, and seize the opportunity to build forward better in order to achieve a just and sustainable future in which no one is left behind. Lofty words. How can it be done? How can it be accomplished? Junior just talked about the Equal Rights Amendment and how long that has taken to be at the cusp of being part of the Constitution, a very, very long time. Franklin said at the very beginning, this is what we need, an ERA in the US Constitution. How long will that take? How many generations? How will it be done in this political environment, which is so divided at this particular point? We are talking about, as you read the newspapers, civil war, potentially, in this democracy. I'd say that the focus in the U.S. for the time being must be on the 6 states with ERAs and the 15 other states working on amending their constitution. As Julia pointed out, in Montana, that's where they're focusing some resources and attention. If so many other states had ERAs, it would be a different scenario altogether. So in order, we have to use these state ERAs, and hopefully in another month or so, New York will join the field. And over the next year, I'm working, as John knows and Franklin knows, I'm working with this effort in Maryland to amend the Constitution in that particular state. A lot must be accomplished in a short period of time, ladies and gentlemen. We have a huge problem as a practical matter, and climate change is no longer an existential threat. It is here. If that report is true from Germany, 85% of the world's population have already been affected. It can only get worse. I want to thank you for allowing me to bring you this good news, if you will. It's good because we know what is happening. Now we must come up with ways in which we can deal with this issue, which is here, which is now. So again, thank you, and I look forward to responding to any questions that you may have. Jana?
Thank you so much, Barry, and thank you to all of our panelists for your really, really insightful presentations. We will now jump right into our Q&A. So just as a final reminder to our participants, please do enter your questions using GoTo's question box. And I see that we do have a number of questions already. I think this one here is a good one to start with. This person asks, can Senator Curry comment? And I would actually expand this to all panelists. Can we have a discussion on overcoming the difficulty of getting 2/3 of Congress and 3/4 of states to vote for a constitutional amendment given today's political realities? So Senator Curry, perhaps we can start with you, and we can go down to anyone else that wants to jump in on this discussion.
Well, of course, as a retired politician, I absolutely agree. It's going to be an uphill fight. Chances of getting this through in the immediate future are very much uphill. But on the other hand, we have two choices: quit or try. And I'm for trying, because this climate change is getting so bad, it's so overwhelming that one of these days, Congress and the states that are slow are going to wake up to the fact they've got to do something. And I think the sooner we start it, the sooner we get pushing, the better off we're going to be. So I recognize that it's going to be hard to get that, but I say I wouldn't let that stop me. We've got to try. I don't want to quit.
Yeah, I'll add on to that. I don't think this is an either or. I don't think this is seek constitutional amendments or pursue the path we're pursuing in the courts. I think it's all hands on deck on every front. We are in an emergency. And the reason we chose to go to the courts to protect rights that we think are unalienable, that don't need to be written in a constitution to be protected, is because we're out of time to work through the political process. And the political process has failed entirely on this issue. But I do think it's really important to have short-term and long-term strategies. And even if it takes 100 years to get that environmental rights amendment passed, I think it's worth doing. And hopefully in places like New York and Maryland and other jurisdictions, it will be a shorter time frame. And so I think we need to be working on every front we can right now. But I do want to emphasize that just as I, as a woman, don't believe that my rights have to be explicit in the Constitution in order to be recognized and protected, I don't think the right to air and water and the climate that all of our lives depend upon has to be written in a constitution for a court to protect that right. And so I just want to be clear about that.
Well, I just want to add, I certainly hope you're going to prevail, Julia, because you put so much time and effort in this, and you've got the case on your side. You just got to get the courts to agree. But one of the reasons, besides your great judicial efforts, is we need an amendment to the U.S. Constitution. Because if it takes effect, then everybody who takes public office in the United States, whether a member of the House or the Senate or the presidency or the courts, must take an oath to uphold the Constitution. And if some version of Article 1, Section 27 is there, that means they're taking an oath to uphold it. And that's what is not explicit now, but we'd like to make it that. So that's one of the reasons I think we've got to keep pushing and see how far we get. You never know. I think it'll happen eventually. How long, I don't know, but we're going to try.
I believe that there should be a shotgun approach. I agree with Julia. The fight must be in the courts, in the streets, in the legislatures on the local, state, federal levels, in the universities, academic institutions, every aspect of American life, as well as in international courts and being part of international bodies. We talked about the UN resolution by the Human Rights Council. That's a prelude, hopefully, to the General Assembly supporting such a resolution. I talked about the fact that there were 4 extensions: China, India, Japan, and Russia. We shall see if the United States, if it goes to the General Assembly, decides not to vote for this human right to clean, healthy, and sustainable environment. I'm hopeful, but that has been a problem for many years. And let me say, I represented the United States in many of these international forums when I was with EPA and part of the Office of International Affairs. And one of the problems there was enforceability. The United States has taken the approach that unless it's enforceable, we're not supportive of a broad human right. So we'll see if things will change as far as the Biden administration is concerned. But going back to my a point that I was making, and I agree with Julia, it's not a question of quitting or not trying, to quit or try. It's a shotgun approach, and we must be effective. There has to be people working in these areas, but knowing what the other hand is doing and how that effort is going. Only if it's a coordinated and concerted effort will we really make progress. And with the 15 states that are working on ERAs right now, and the 6 states and hopefully 7 states that will have effective ERAs, we shall see. But we have got to deal with this present problem of climate change. It's not a threat anymore. It's real.
I just want to clarify something. I'm not suggesting that Julia or others stop their judicial efforts or Barry, we stop at these states. My argument about is for amending the U.S. Constitution, and the others should absolutely keep going. I'm not suggesting anybody else slow down.
Great. Well, I think that's a great way to start our conversation. And we have a follow-up question that I think gets to the heart of some of this debate at what level and what mechanism we take climate and environmental justice action. And I think this question is really interesting to follow up on that. The question asks, I'm curious what the panel thinks of NEPA which the courts and rest of us therefore ignore. These parts remind me of a sort of overall protection that a constitutional amendment would address. And then they follow up saying, I'm thinking specifically of the quote, in quotes, Congress recognizes that each person should enjoy a healthful environment. So I guess to clarify that question is, might NEPA have a role as part of this that perhaps we haven't been touching on? So I will leave that to anyone that wants to start with it, or I can start calling on folks.
I'll jump in on NEPA. I used to litigate under NEPA a lot, and NEPA has an interesting history. It was one of those statutes that was adopted in the 70s, and originally people like Professor Bill Rogers were arguing, and many others were arguing, that it should have a substantive hook, that it had more than a procedural meaning to it. But over time, the courts have just interpreted NEPA as requiring process and not substance. And so I think NEPA, like many of our environmental statutes, actually do articulate the public trust obligation of government. They do articulate the right of the people to clean air and water and the benefit of natural resources. And they articulate that intergenerational justice principle. But they have not been interpreted by our courts to be substantively binding on the government in that way. And so while we use that language actually as evidence that there is a federal public trust obligation in our Juliana litigation, but again, NEPA itself is not binding in that way. It's a process statute.
Well, this is why I'm urging an amendment to the U.S. Constitution, because that will override all of these statutes, which are good and helpful. But if you get in the Constitution, then everybody is bound to uphold it, at least by taking the oath of office. So I think you need to make a fundamental policy statement of our government that it's going to protect the environment and our health and so on. So that's why I'm for the amendment.
So go ahead, Barry.
Go ahead, John. No, you go ahead, John.
If we're both polite, no one proceeds. So, okay, I'll proceed. So to build on what Julia and Franklin said, I would add, sort of going back to the two parts of the Pennsylvania amendment. The public trust part of it obliges the government to conserve and maintain public natural resources, period. That's a substantive obligation. And one of the conversations that we've had in Pennsylvania has been, well, so to what extent does the government have to think about the impacts of what it's going to be doing in advance? And I think that there is, at least among a lot of people, some understanding that the substantive obligation brings with it a procedural obligation to do at least some investigation in advance, which would be like NEPA. But the environmental amendment itself has substantive bite on that in terms of the obligation to conserve and maintain. It's not limited to one statute, and so it's broad in the same way that NEPA is broad. With respect to the first sentence of the amendment, giving people the right to clean air, pure water, and the preservation of certain values in the environment, the court has made it clear that at least as against the government, okay, the government can't do things that are going to interfere with the public's right to those things. And again, that has substantive bite. The challenge you get into on the substantive bite part of this is to what extent does a court get to second guess a decision about, for example, an emission limitation of 2 parts per million? All right, and we haven't gotten to that point yet, but at least with respect to the first sentence, I could see at some point where we might. How much deference do you give the agencies? All that kind of good stuff. But the point is that even at a broad level, without getting into that kind of detail, the potential for the substantive bite is what is getting developers, I think, in many cases to say, hey, you know what? Maybe a statute or regulation doesn't address a particular issue, but we better. Otherwise, we're going to have Section 27 litigation. So the substantive bite is actually a real part of how the Environmental Rights Amendment is now being experienced and applied.
Well, I'll say the other bite is that if you have, it's in the Constitution, citizens can bring litigation against the government to make them live up to their duties. And that in itself would give the government a reason to take a different approach towards the environment than it does now. That's the real hooker here, is you got to give people the right to go to court. And statutes don't do that the way a constitutional amendment does.
Talking about a statute, the National Environmental Policy Act. This is called the Magna Carta of Environmental Law, NEPA. And if I can recall from my administrative law class, where we looked at statutes, you mentioned that everyone is entitled to a healthful environment. That's in the section, I think it's 101 of NEPA, that talks about Congress fines. Now, Congress's finding, does that mean that it's part and parcel of the regulation? It's a finding. It forms the basis for the act, but can you use it in order to move forward, a court to move forward on that? I don't know. But let's look at NEPA, and this goes back to what Franklin is saying, that it should be a constitutional amendment because another administration can change things. Look at what has happened with this whole notion of cumulative impacts. I mean, this was an incredibly important feature of NEPA as it relates to community-based organizations bringing actions under NEPA, lawsuits under NEPA. But the Trump administration eliminated entirely cumulative impacts in its July 2020 final regulations. Just last week, the Biden administration published in the Federal Register a proposal to bring cumulative impacts back. Now, as Franklin said, with an amendment to the U.S. Constitution, it may be a long road. It may take time, but it's something that is very different from a statute, which can be amended, which can be changed, which may not even be enforced by an administration. That's the problems that you might have with NEPA regulations. They're good. They've been used for 40-something years. Everyone was used to NEPA, but what happened when the Trump administration changed the NEPA entirely? We're back to the drawing board. It's going to take the administrative process to make these changes again to what cumulative impacts was all about. It may take the rest of the Biden administration over the next 2-3 years. We shall see.
Excellent. Thank you all so much. I really appreciate that conversation and dialogue. We have another question here, and I think this one is really kind of asking to highlight some of the best examples that we have out there on success stories. So the question asks, outside of Pennsylvania and the Philippines, what would the panel say are the legal case decisions that best show the effectiveness and implementation of a constitutionally recognized expressed right to a healthy environment? Do you have specific cases? Where and what were the outcomes?
Well, I would say,
Go ahead, John.
okay, I would say, I mean, I'm not going to give you specific cases, but I would say one state, this is kind of a Rodney Dangerfield point, but one state that doesn't get the respect it deserves for what it's done with its environmental rights and public trust language in its constitution is Hawaii. And some of the most progressive decisions that you're going to see from any state court come down in Hawaii. There's a couple of good decisions that come out of Montana. And increasingly, you're seeing decisions on this issue come out of courts from other countries. And there's been a series of cases that have Germany was one recently on climate change in their constitution. And there are other cases that are coming out of other countries as well. it is actually more and more of that kind of litigation and more decisions all the time.
In the book,
I-
I have a chapter on these cases. I can't remember the cases offhand, but I know they have cases that John points out Montana and Hawaii are really good. Another great country with a place for the amendment type language is in the Philippines, which has had stunning cases against invasion of the environment. So it's there if you. It's all there. It's really these amendments do really have teeth.
I'm going to mention a not a case, but a system, a process, if you will. I talked about New York being on the verge of is going to a public referendum in November for the ERA to be passed. It's simple, it's straightforward, it's self-executing, it's just one sentence. So that's a good thing. New York already has, as of last year, an environmental justice piece of legislation. New York also has climate change legislation. So if I looked at a state and I'm thinking about the possibilities of things happening from a progressive point of view, I would say that New York holds a lot of promise from my perspective. And so instead of talking about a particular case that has already happened, I'm thinking about cases, I'm thinking about issues that will arise in New York where they have all three of these things functioning properly. So there is hope as far as the people of New York are concerned.
One other country I'll just throw out, Pakistan has some really amazing cases too, and on climate, and I would argue maybe some of the most hard-hitting and progressive decisions coming out of their courts on the issue of climate crisis, using their strong public trust provisions.
Excellent. We have time for a couple more questions. This next question I think is a really good one, and Julia, I think it might be best to start with you on it. The question asks, what is the role of climate scientists in courts? And before you answer, I would also like to just give a quick plug to ELI's Climate Judiciary Project. You can find that on our website, and I would highly encourage you to look more into that and get involved. But Julia, I think that question is best to start with you.
Yeah, thank you. That's actually a question I'm really passionate about. I think it's our job as lawyers bringing cases to enforce these types of constitutional provisions or bringing implied rights cases to bring to judges the very best climate science that's available. And what I am seeing in a lot of litigation around the world is lawyers defaulting to the Paris Agreement targets. And those, I'm sure most people on here know, they are a 2 degrees C limit with a goal of staying no higher than 1.5 degrees Celsius of heating above pre-industrial temperatures. But when I talk to climate scientists, every single one of them says those levels of heating are catastrophic for humanity and for most life on Earth. And so, just to be clear, if we sustain temperatures of 1.5 degrees Celsius or even 2 above pre-industrial temperatures, we'll melt all the ice on the planet eventually. And we will have, an increase. Imagine we're at like 1.1, 1.2 right now. To have additional heating, that means life out west is going to be substantially different, right? Our forests are going to burn, our air is going to be filled with smoke. The flooding that's happening in the east and the southeast will continue to get worse. So what I ask as a lawyer, what I ask scientists is, what level of atmospheric carbon dioxide would actually stabilize our climate system for my clients? What do we need to try to get back to? Because it's really the CO2 levels that are driving the temperature changes, that are driving these other consequences. And And what they all say across the board is we need to return to less than 350 parts per million of atmospheric CO2, ideally by the end of the century. And that level is really important because that's what it takes to stabilize the energy imbalance of the planet, right? Our planet is out of energy balance. We have too much heat coming in. And in order to stop that problem, we have to bring CO2 levels way down. And there's two ways to do that that are both essential. It's reduce emissions very, very quickly and increase the carbon sequestration capacity of our soils and our forests and our wetlands. And we need to bring in the most cutting edge science into court. And so I just encourage, any lawyers working on this litigation or people thinking about amendments, I think having a requirement in a constitutional amendment that the best scientific evidence will be used to define what it means to truly protect these life support systems. Because we do our children and future generations an enormous injustice if we use politically negotiated targets, which are not adequate to protect our climate system, as a standard for protecting a human right. So I think getting real about the science and what's necessary is really vital to all of these cases.
Excellent. Thank you so much. I don't know that we have time for another question, but instead, I think it'd be great if we could have each panelist just go give us, a minute of your concluding thoughts. And I think we should start in the speaking order that we had. So Franklin, I'll start with you, then we can go to John, and then Julia, and then Barry will close with you.
Well, the main thing we have to realize about climate change is that the United States cannot save the planet by itself. It's really got to get an agreement with the big contributors to the carbon emission, which is China, India, and the European Union, and maybe one other country. But if we get together with them and get agreement, we have a chance to save the planet. And I think the environmental amendment, the basic principles of Article 1, Section 27, are a good basis to deal with and to offer to the Chinese and the Indians and the European Union to get agreement on. And the best way we can get that done is get it started on our own here in the United States. So at least the progress is being made toward putting that in our Constitution while we're talking to the big contributors around the world. So that's why I think the case for an amendment to the U.S. Constitution is overwhelming.
To which I would add that amendments to constitutions or even constitutional provisions tend to become public values over time. So we talk about separation of powers, for example, as something that is important to us and is not simply a particular way that the Constitution works. And what happens when you constitutionalize public right to a clean environment or public trust requirements for protection of the environment is those things over time become reflected more and more deeply as public values. And that in turn contributes to their effectiveness in ways that are different from what you would get if you simply looked at a variety of different judicial decisions. So constitutionalizing all of this is important as a way of building public support for the kind of work that still needs to be done.
I'm next, Chandler. Yeah. I totally agree with what Franklin and John just said, and I would add that while the United States can ultimately help save the planet in partnership with other countries who are primarily responsible for emissions, I think the United States alone does have the power to tank the planet. And the United States is the single country in the world that won't ratify the Convention on the Rights of the Child. And it's my understanding that we are also one of the few countries that does oppose what the Human Rights Council said on Friday, that the right to a healthy and clean and sustainable environment is a human right. And so I just want to point out that there's a lot of reasons for that, right? And money is a big one, money and power, and an entrenched fossil fuel energy system. And it is going to be the battle of our lives to bring the United States government into compliance with basic human rights and its trustee obligation to present and future generations. So I hope that everyone will really stay tuned on what happens in the next phase of Juliana to hold the Biden administration accountable. We need all hands on deck in the streets, in the courts, working on constitutional amendments. And this is the moment. This is our moment. Thank you.
Let me just quickly say that about rights against privilege. There's a huge difference. In June of 2010, the UN General Assembly said that there should be a human right to water, a human right to water. Plants, animals, everything needs water. Humans need water in order to survive. The United States abstained from that particular vote. We have seen problems here in the US as it relates to access to clean drinking water, not only in Flint, but I read something the other day about another Michigan community, predominantly African American community. They're telling them not to drink the water. So it is a privilege at this particular point. Everyone on this panel, everyone participating in this webinar, we don't have a constitutional right, a human right to clean water. That's something that needs to be addressed. And so I'll just end there. We have a privilege, not a right.
Well, thank you all so much. And thank you to our audience for joining us today and for your many thought-provoking questions. I hope you'll continue to watch this space in the years ahead. And I think this is definitely a panel worth continuing the conversation on in the near future. I really enjoyed it and really appreciate each of our panelists' contributions. Thank you so much to Franklin, to Julia, John, and Barry. Just really appreciate your thoughtful comments and discussion and dialogue today. Thank you all so much. Please take care and stay safe. Thank you, everyone.
Thank you.
Thank you.
Thank
Bye-bye.
you. Bye.
Yeah.
It's very nice.